Thank you, Barry. Let me invite the panelists to come up and take their seat for the first panel, Preventing Platforms from Manipulating Speech and Information. But before we jump into this really topical issue, considering the Supreme Court is supposed to come down with a decision tomorrow on net choice, we're going to hear from Representative Ken Buck, a congressman from Colorado who has sent some brief remarks.
Hi, this is Ken Buck. I want to thank Barry Lynn and the Open Markets Institute for putting this forum on. I want to thank you for being here and welcome you to this forum. I appreciate your interest, and I hope that you can generate interest around the country in what Barry is trying to do and has been trying to do for years. I am really concerned about where we are right now with the state of competition in the tech area for a number of reasons. When I look at America historically after the Civil War, it was clear that monopolies had developed in banking and oil and gas, in railroads and other areas. And those monopolies created inefficiencies. They created increased costs for consumers and huge wealth that was used politically to influence our system in the United States. The Congress, in a bipartisan way, took action and made sure that we limited those businesses and broke up many of those businesses and created a system that has really benefited the U.S. economy and has influenced the world economy in a lot of ways. The problem we face now is we have dramatically changed the type of economy we're dealing with all the online internet, but online marketing and consumer actions. And so I think that it is really important that we not only update the Sherman Act, the Clayton Act, other laws, but that we understand that what happened historically is going to continue to happen until we take that action. If we don't update the laws, we are going to see a consolidation of power, a huge use of resources to impact our political system and stymie the kind of competitive laws that we need to implement in this country. And what's ironic to me as a conservative is I have always believed and have always talked about the fact that we need to make sure that Article 1 of our Constitution, Congress, the legislative branch, is doing its job. We don't want judges to be activists. We don't want judges to anticipate what Congress would have done if it had acted properly. We want Congress to legislate and not the courts. And what we're seeing with many of my friends on the right is a reluctance to allow Congress to enact the legislation that it needs to enact because of the huge political resources that are being brought to bear. The impact of these monopolies, Amazon, Facebook, Apple, Google, is really detrimental, and some of it can't be undone at this point. We cannot reverse the damage that has been done to journalism, for example. The idea that huge amounts of money are being taken from those creators of good journalism and siphoned off for huge profits by these companies. And by the way, I don't think profits is a bad word. I think it's a very good word as long as it incentivizes innovation. I think it's a great word. But when you siphon off profits and shut down small newspapers across this country, you change the character of America in a bad way, I believe. And so we have to make sure that we pass some of the legislation that's in Congress that would give back to the creators of content the resources that they need to continue to hold government accountable, to hold business accountable, to inform our electorate, our voters, our citizens about what's going on in their local communities. The other danger, these platforms have created so much wealth that they are affecting and infecting the political system. The idea that a group of companies, a small group of companies, can spend $400 million to defeat a handful of competition laws in this country is obnoxious. And if most people understood the damage that was being done, I believe that they would be upset and demand that their representatives acted differently. So and I guess the last point I want to make is speech is different in this country than it is in the rest of the world. Our First Amendment has evolved in a way that we believe that more speech, that true speech, counters false speech. There's going to be obnoxious speech on the internet, on various platforms, and that is bad, but it shouldn't be regulated by the government or by a group of Silicon Valley executives. The way to deal with false speech, disinformation, dangerous speech is more good speech, true speech, and making sure that people understand what the truth is. When we start allowing a handful of people, no matter what group they come from, government, business, internet providers, whatever group they come from, to decide what is true and what is false, we put ourselves as a country at risk. I think censorship is one of the most evil uh, outgrowths of the pandemic, and this idea that we can tell people the truth as if somebody has a hat on that tells them this is the truth and this is the only truth we're going to allow. So thank you. I hope I've added a little bit of value to this discussion. I'm sure I don't have a lot of people who agree with everything I said, but hopefully it is of some value. Barry, thank you for inviting me to speak, and God bless all of you and your efforts. Thank you.
This, I think, is the perfect setup for this panel on preventing platforms from manipulating speech and information, and doing that in a way that respects the First Amendment, but also recognizes that there's no such thing as a free marketplace of ideas, and that market is structured. One of the battles, in fact, over this very topic is playing out in the courts as we speak, and a decision is expected tomorrow, I understand. The Supreme Court is currently hearing a set of cases that will determine whether big tech platforms should operate fairly for all of those who use them, and whether policymakers will be able to use the tools in their toolbox, to deal with them. Less than a handful of corporations control the platforms where we share ideas, engage in public discourse, and access information. Their search rankings, they can make or break a business. Recommendation algorithms have been shown to breed extremism. Instagram's pernicious impacts on teen mental health, Facebook's unilateral and capricious content moderation, all of these helping to create businesses that earn up to 80% of their revenue from digital advertising. So, with this setup that I think Representative Buck and the EU Commissioner gave us, we've recognized, Will Aramis said, an industry does not get labeled big with a capital B out of respect and admiration, but rather out of loathing and fear, and in preparation for battle. And so we're actually seeing that battle happen right now. So Zephyr, I want to go to you first. You're a professor of law at Fordham University. And net choice is essentially about whether tech corporations that are protected from liability for the content on their platform should have First Amendment rights, and whether states can impose common carrier obligations on these intermediaries. Can you explain, why is this case so critical, and why should we force platforms, as you put it, to embrace their role as essential infrastructure?
Thank you.
There should be a mic on the...
I need my microphone.
Yes.
Thank you, Courtney. We thought the net choice pair of decisions might come down today. They did not. And I don't want to eat up 25 minutes talking about what net choice is, because the truth is it's about 20 different things, and depending on how it comes out, will have really different impacts. It's important because it's the first time the Supreme Court is weighing in on how to think about what is TikTok, what is Facebook. Are they like a newspaper? Are they like a mall? Or there's something totally differently? And I put that maybe in there because this court likes taking really big cases and then kind of sneaking them out the door. So that may happen here. Why I think this is so important. Yesterday, 2 days ago, Instagram, which between a third and a half of Americans have an account on, turned off the politics feed the day basically preceding the debate. When they were asked about it, Meta said, oops, that was an accident, and turned it back on. That is an extraordinary and disturbing amount of power for the whims of Mark Zuckerberg, the mistakes of one man, of a tiny group of men, that their capacity to control and shape public discourse. So what we're talking about today, I just want to put a fine point on what I see the particular problem we're talking about today. Because you can think of social media like climate change. There's lots of different problems here, right? I want to talk about what I want to focus on is the particular problem, which is the way in which Facebook, Instagram, Google, including YouTube, Amazon, Twitter, have seized control of the media infrastructure of this country.
Okay, so wait, given that, we know the problem, right? That's the thing is, what is the solution?
Oh, okay.
And Net Choice is proposing, the proposed solution is let's treat them as common carriers and impose non-discrimination. So why do you think this case will fundamentally shape, and why is it important that we get this right?
The reason I'm resisting you, Courtney, is because I actually think the court shouldn't have taken this case, and I hope it sneaks out the door. It was premature. It's a facial challenge. It's asking about a whole bunch of complicated questions all at once. What's important, I think, and I don't want to today tell you that if Net Choice goes the way I don't want it to, then we can't actually act, because there's already too much disempowerment. So I'll do a quicker version. I got you. The two big problems are the concentration of power and the nature of the algorithmic feed. And both of those are not essential to the internet. And I think that's the most important thing I want to get across, is that you can have the internet, as we did in 2006, without either the introduction of the targeted feed that comes in 2010, 2011, or without the concentration of power that we see through the gobbling up. And so when I think about solutions, it is along the lines of the three key tools of anti-monopoly are divestiture and breaking up, critical. YouTube doesn't need to be owned by the same company that owns Maps. Non-discrimination rules, limiting how differently, and the two cases, the Florida and Texas case, are really bizarre examples of a kind of non-discrimination rule, saying you can't treat different counterparties differently. And then particular forms of consumer protection laws that protect against abuses that come along with those big forms of power.
Thank you. And I know, that we can talk a lot about the problem, but one of the things we do want to talk about today are some of the solutions, especially because, we have a very important election coming up. We want to see what can we do in the meantime. And so, you mentioned so many accidents. There are so many accidents when these platforms accidentally do something. Tara, in the amicus brief that OMI filed in support of the states, which is, kind of odd bedfellows in some respect, you wrote that the underlying question of whether states and the federal government have the authority to regulate social media and other internet platforms as common carriers is critical. So tell us, how would treating platforms as common carriers and imposing non-discrimination rules actually help? And Tara is our policy counsel at OMI, so.
Yeah, we filed a brief in Net Choice, but another case that isn't getting as much attention, we really need to throw out, make sure everybody knows about, is Ohio v. Google. So Ohio is currently trying to make Google a common carrier under their state law. So one of the things that the reason that we filed a brief is that we're afraid that the court could say, well, you can't regulate them as common carriers. And we think this is ridiculous. So we took a really narrow approach when we looked at this case. We said, okay, we're not going to really opine on the law itself, but we're just really talking about, should states have the power there to regulate tech companies as common carriers?
Why do they need that power?
They need that power. One of the reason is because one of the things that they're seeking is to have open access, right? Basically, everybody should be treated the same, right? So whether it's getting on an airplane, everybody, if you can buy a ticket, you get there on time, you're not on the no-fly list, then you can get on the plane, right? Same with hotels. They have to give you a room. Same with restaurants. It's open access and equal access. And that's really important because these tech companies are not treating us equally. Some are getting better, more, let's just say, they're being pushed. And they like to push the the most controversial subjects in order to get more people engaged, because, as they say, engagement through enragement. So they want to enrage us so that we continue to scroll. As we continue to scroll, they keep feeding us more advertising, and hopefully we click on a button and we buy something. That's the point. Their point is so that they can sell more advertising to us, so they can get more information about us, so that they can get more targeting advertisement. So this will make it sure that everybody has access, including media. This is important because, as you mentioned, they just cut off feeds. Or in Facebook, when Australia tried to have, and Canada tried to pass a law saying you have to negotiate with the media, they said, oh, well, then we're just going to shut off the media feeds. And, they did that in Canada during the worst wildfire season in the history. So it really was impactful. So that's one thing. Another thing that we really pushed back on was their idea that they are somehow special. These tech companies want to say, well, you can't regulate us because we're somehow different. We're better than. But really, they're just an information. They're just like the telephone. There's a way to communicate with others. So if we can regulate telephone companies and Telegram and the Postal Service, and we go back in time, right? As technology evolves, the law evolves. And so we say, as the law evolves, this common carriage law, it's 500 years old, you guys. It goes clear back in the Middle Ages. It has evolved significantly over time, so we can't just say, oh, well, tech companies are better, stop here, put a pause on it, we're going to move on. No, if it continues, if it has evolved in the past, it should continue to evolve. And the last thing is this idea, this is something that the tech companies want to complain about, is that, oh, well, if you do this, then everything's going to come out, it's going to be horrible, it's going to be non-usable. They can continue to moderate, right? The reason that these Facebook and Twitter and these other companies are useful is that they do moderate. There's some kind of curation going on. I don't know if you all remember going to the old websites, those little chat rooms in the days. Maybe I just aged myself. But they were basically useless. So the curation is kind of the point. And none of these laws are trying to remove their ability to curate. We're just saying maybe we should curate in a way that isn't so harmful, maybe especially to children.
Well, and that you need to clearly define and convey the rules. So, no secret cross-check program where certain speakers get extra amplification.
And that's important because it's also not just who you're pushing, but it's also promoting. Google in particular is really about self-promoting. They will push their own products. Well, if they have a competition, we know this in Google Shopping, the old Google Shopping case. They took the other shopping case websites and they pushed them not just down to the bottom of the page, to the next page or the third page, so that they had prime spots while their major competitors were pushed off the page. That's the big problem.
And that, of course, further consolidates their power. How convenient.
Yes.
But, one of the things that so as a freedom of expression advocate and journalist for the past 20 years, I found it odd to be on the opposite side of a lot of people that I respect and have worked with for a long time on these issues. But, I think, Marianne, you have written about what you call the cult of the Constitution. You're a professor now at GW Law School, and you've talked about the cult of the Constitution, especially with respect to the First Amendment, which I think many people and big tech claim makes it impossible to impose such rules or fix speech and information flows on tech platforms, despite the fact that, again, on cable, we made it a common carrier. They're required to carry local media, for example. So, you've also written in your book, you pointed out that online intermediaries get to have it both ways. They are granted immunity from other people's speech under Section 230, but they enjoy the rights to other people's speech under the First Amendment. So how should we reconceive the scope and nature and definition of constitutional rights to avoid protecting the most powerful at the expense of the rest of us?
Thanks. And this is the distinction between those two things you just mentioned, the immunity on the one hand and the kind of entitlement in the sense of the First Amendment on the other, I do think is maybe what puts me a bit apart from the other panelists, that what I think that the real problem has been to lead us to this moment where I agree that we have all these incredibly harmful effects of this domination by a small number of companies is in part because of a misunderstanding and an idealization of the First Amendment. And I want to be very clear about what I mean by that, that for 20, 30 years or so, the tech industry has been saying when people have criticized harmful content, they've said, we don't want to take harmful content down because that would be censorship. We don't want to do anything about non-consensual pornography, which is the issue that my organization, the Cyber Civil Rights Initiative, is focused on. We don't want to do anything about harassment. And the reason that they said that they didn't want to do that, and the kind of legitimacy they gave themselves and the reputational benefit they gave themselves, was to say, we are here for your free speech. We are here to emulate the First Amendment. That was always wrong because, of course, they're not obligated under the First Amendment to say we can't take anything down. When the First Amendment, what the First Amendment actually does, of course, is it sets up one rule for the government and another rule for everyone else. The government is not supposed to take things down. The government is not supposed to discriminate on the basis of viewpoint. It can in some cases, but it is generally not supposed to because the government has a lot of power, and it's unique forms of power. It's not just like commercial power. It is the kind of power that we really need to be afraid of. Non-governmental actors, by contrast, should be taking things down. They should be able to dissociate from speech that they don't like at any way they want. And in fact, that is vitally important to what a non-government actor's right under the First Amendment really is. It's the right to say, I don't like your speech. It's the right to say, I'm going to ignore your speech. It's the right to say, we don't think there should be revenge porn all over our platforms. Let's take it down. And it's also the right to say we only want Republican content or Democratic content. As much as we might think that's a bad policy choice, or maybe we don't like any kind of social media platform that does that, they have that right under the First Amendment.
Unless they're designated as common carriers, right? And that's where I think this really interesting solution comes in, because you have a lot of people arguing that they have the First Amendment rights. Wouldn't then common carriage provide an opportunity to strike that balance?
And I'd say that's one of the reasons why I'm very skeptical of the common carrier argument, partly because we're not just talking about telephones and we're not talking about railroads. Whether we like it or not, the social media platforms are offering a different kind of service that is inherently expressive in a way that those kinds of things simply aren't. And so I think when, on the one hand, what we can say is it's just not the right model because they are doing something different. It is a kind of voluntary association, even if it's a very powerful one, but it's not the same thing as getting you from one place to another. The other thing I would say about this is that even when it comes to treating these kinds of entities as common carriers, I don't think it would do what a lot of people want it to do, which is to say, even if you're a hotel that says we can't discriminate on the basis of certain types of characteristics, and that's good, right? Keep in mind first that those characteristics are not things that relate to your opinions about the world. They're characteristics like your race, right? If we want to say, well, Facebook can't discriminate on the basis of race, that's probably fine and good, right? But the hotel can still eject someone that comes into their lobby and starts screaming racial slurs. And they ought to be able to do that. They ought to be able to have policies and procedures that say, we're not going to let you be here if you stand in our lobby and use our services and do something terrible. And so I still think on the one hand, for instance, what Florida and Texas is trying to do, what they're really aiming at is they're trying to say, hotels, you have to let those people stay. And that, I think, would be a very bad practice.
So I think we would disagree, and I saw, Zephyr, that you definitely want to get in on this point. And I think that, one of the problems is there is this misconception of common carriage and how we can apply that and how we have applied that to information communications systems as they have developed. And so, Zephyr and Tara, do you want to jump in on this?
Well, it's useful because we have three different views, actually. It's even though Tara and I don't disagree, we're representing three different views. One is don't use common carriage. The other is do use common carriage. I'd say you don't even need common carriage. There is a long history of broadly non-discrimination laws which are absolutely essential to common carriage regimes like phone service regimes, but also exist outside of that in a whole array of areas. And what I am most concerned about, and I do want to move on from NetChoice because there are some real solutions, but this is related, is that we are for the first time in the last 5 years starting to see at the state level, at the federal level, real action to take on the real human harms and the democratic harms of big tech platforms and of algorithmic AI, maybe even of generative AI. And at this precise moment where you want creative local energy, not creative local energy that's trying to quash particular viewpoints, but creative policy energy, what the big tech companies want to do is say, stop, we've got a First Amendment don't even be creative, don't think about solutions. And that they're trying to basically put the kibosh way too early on, I don't think they ever should, but way too early on the ability of legislatures to do what they have been doing, as Tara was saying, in all these other circumstances. So there is a real difference of view. So can I talk about what we were doing in New York, for instance?
I wanted to hear about, because you're looking at algorithmic curation.
Yes. So I spent some time working at the New York Attorney General's office. I'm no longer there, so if it says on your program that I am, I speak wholly for myself. I'm back teaching at Fordham, but while there, I worked on a bill that just passed last week that prohibits, for under 18-year-olds, prohibits platforms from using personal information to deliver content. So the children who never search for suicide content but get barraged with suicide videos, that stops. Using your most precious information, how long you hover over a video, how you feel about your friends, your tone of voice, your keystrokes, to determine what TikTok or Instagram, that stops. So it's a consumer protection law. I mean, as somebody who comes from anti-monopoly, I'd say it's also a non-discrimination law, because it's saying you can't treat different counterparties differently. But we got it through. We got it through with a unanimous support in one house and all but one vote against in the other, with the support of the governor. All that the big tech companies were saying was First Amendment, First Amendment, First Amendment. And they were basically saying, why try to pass a law when it's going to get struck down anyway? So they're actively trying to chill our imagination at a critical time where it's important to build that imagination. By the way, once this law goes into effect, I want to use that service because I want my agency back. I want to choose my own news as opposed to have it forced down by whatever Zuckerberg wants me to be reading.
And of course, this attempt to manipulate the democratic legislative process we're seeing around the world. Tara alluded to what's happening in Canada and Australia and California, and we'll be talking about that on a panel later this afternoon. But in terms of addressing this problem of algorithmic curation, of secret rules that change, whenever something comes to light, all of these multifarious accidents that keep happening, including, genocide in Myanmar and other really terrible harassment, et cetera. I mean, how can we, if you could have one policy implemented tomorrow, what would that be to address this particular issue? I'm going to start with you, Marianne, because I know you've worked on a lot of legislation.
Yes, and the one that, if I just had to pick one, it would be to reform Section 230C1. And I do want to make it really clear that I'm talking about C1 and not C2 for exactly the reasons that we discussed before, which is, for those of you who don't know, Section 230 provides immunity from both civil and criminal liability, really sweeping immunity, according to C2 of Section 230, if you're trying to do something to limit content. Let's say that you have decided that you're going to put in filters, or you're going to try to have policies that take down certain types of harmful content. C1, by contrast, and in a way that I think does not make any sense, has been interpreted to say you get the same kind of immunity and you get all of those protections if you do nothing about harmful content. And it even says, it has been interpreted by the courts, essentially to say even if you're monetizing that content, even if you're promoting it, even if you're pushing it on people, you still get to not be sued. That, I think, is just a very grave and serious problem that we have to address. And so my targeted reforms for C1 would be to say, first of all, limit what we're talking about here to speech as opposed to the word information, which is what is currently used in C1. That's way too broad to apply to any number of activities that take place online. But the second one would be to say you do not get immunity for things that you yourself as a platform, as a service, are benefiting from, are pushing out to the audience. And so I would take away that immunity. I think that would do a lot to help the situation that we're in.
Zephyr, what about you? I mean, it's great to protect kids, but what about the rest of us?
Okay, I've got three.
All right.
But I do think this is like climate change, so we shouldn't look at it like the one thing. It is actual activity, and constantly, the state experiments really do matter. So one is reforming 230. These are old common law ideas. Talk about 500 years old. If you sweep the sidewalk in front of your restaurant and somebody slips and falls, you're liable. When you take an active action, sort of the voluntary action principle in tort law, when you take an active action and are no longer a neutral platform, you're liable. So basically, when something is algorithmically promoted, liability. 2, divestiture, and blocking new acquisitions, because this concentration of power is a huge problem. And 3, non-discrimination laws, including like the JCPA that's being pushed federally to make sure that big platforms or COA cannot discriminate between different news organizations based on their viewpoint. But I think there's also more opportunities around non-discrimination. But those are 3 immediate things we can do right now.
Yeah, that would be great. And of course, there is the court case, the Google ad tech trial that we'll hear about in September, and actually will be in the courtroom covering that and specifically what it means for publishers as well as for the broader tech industry. You mentioned JCPA. For the audience, that's the Journalist Competition and Preservation Act. And, you know, the issue around non-discrimination, right? We have seen retaliation against both individual reporters, against individual news outlets, and against then the entire sector of journalism at various points by these companies. So Tara, what about from your perspective?
So I agree with everything that was said. I think essential that we need to reform Section 230. But I'm a former state antitrust enforcer. So just give you like perspective where I'm coming from. So I am very sensitive to anything that will take away the state's rights or the state's police powers. It is essential that the states have the ability, because they're closer to the ground. You know, when I was an enforcer, people would come in and they would actually sit with me and they would complain. They'd tell me their stories. And, you know, it's heartbreaking when you can't do anything to help them. We have to make sure that those that are close to the ground, who know what's going on, can help. And so the state experiments are essential, and that's why we really filed this brief in NetChoice. It was really about the police powers. It was about taking away the state's rights to police the harms that are happening in their own state. So the New York case is fantastic. You know, this is a state who saw a problem, and they're trying to fix it. California is doing the same thing. They have their own laws that they're trying to fix. I did a lot of privacy. Utah passed a privacy bill. So when we find problems, if the feds can't pass anything, states can. So that's why the NetChoice is really important, just to go back to that, is because it's really about the police powers and the state's ability to continue to protect their citizens.
Protecting citizens. I mean, that is what our government is supposed to be about at a very basic level, and it certainly seems that they are failing as they have allowed these companies to grow bigger and more powerful and intermediate our information ecosystem, especially in the year of elections, as this is being called. So with that, I would like to thank you for an interesting and robust discussion. Obviously, there is no one silver bullet, and we've seen that our policy options are also linked up with how the judiciary is going to decide some of these concepts. I'm grateful to have people like you putting in briefs to help the Supreme Court shape how it thinks about these issues. And I guess we'll all be waiting with bated breath to see what happens tomorrow. So thank you so much.
Thank you, Court.